Good afternoon and welcome everybody, and thank you for taking the time to be here today. My name's Julie Wheway and I'm from the Public Education team at IP Australia. Today I'm joined by Firoozeh Rabbani, Senior Patent Examiner here at IP Australia. Firoozeh has worked across lots of different examination groups here at IP Australia, so she's seen a lot of patent applications and we're really looking forward to hearing what she has to share with us today. We are looking forward to taking you through our webinar on unlocking the potential of your IP for research impact. We'll be going through the what's, whys and hows of all things patents in a research context, in addition to a mock scenario, as well as some tips for best practice. There will be opportunities for questions via Slido at the end of the presentation, and we'll put the Slido link in the chat for you to post your questions as you go. I just wanted to also note that this session will be recorded and that we are going to share the slides with all the registered attendees afterwards. Before we begin, I would like to acknowledge the traditional custodians of the land on which we're presenting from today. I'm joining from the lands of the Gadigal people and Firoozeh from the Ngunnawal people. I pay my respects to ancestors past, present, and any emerging leaders joining us today. I'd also like to extend these respects to the traditional custodians of the lands that you're all joining from today, and I'd like to acknowledge that our First Nations people are our first innovators. So who is IP Australia? We are the government agency that administers the IP rights system and legislation relating to trademarks, patents, design rights and plant breeders' rights. And as such, we are a regulatory body. We also contribute to the innovation system more broadly by using our skills and experience to advise government and Australian businesses to make the most of their IP. So what is intellectual property? Intellectual property, or IP, refers to the creations of the mind, a creation of your intellect, and it can take many forms. It could be a mechanical invention, a chair design, a medical device, a new style of shoe, software or a data set, or even literary and artistic works. And it's Australia's IP laws that provide a legal framework to protect your creative ideas through IP rights. It's worth noting that your IP is a valuable but an intangible asset, and it promotes the investment and stims economic growth, which can be beneficial for businesses, but also the national economy more broadly. As I mentioned, Australia's IP laws provide that legal framework to protect your creative ideas through IP rights, some of which need to be formally registered and others that do not. So the registered IP rights that we administer at IP Australia are trademarks, patents, design rights and plant breeders' rights. A trademark is often called a brand, and it's your identity and is used by customers to differentiate your products or services from those of competitors. I guess a great example of this is the Nike swoosh or the Tiffany blue colour. A patent protects new inventions such as devices, substances, methods and processes, and Firoozeh is going to do a much deeper dive into patents shortly. A design right really protects the overall visual appearance of new and distinctive products, and I guess a really great example of this Apple's AirPod case or a Dyson vacuum. And finally, plant breeders' rights, or PBR, provides exclusive commercial rights for a registered variety of plant together with its variety name. An example of this is the Sir Walter lawn turf. There are other types of unregistered IP protection, and these include copyright, trade secrets and circuit layouts, and each of these has its own requirements and rules. So for instance, copyright and circuit diagrams are automatically protected if certain conditions are met. Now, each of these forms of IP protect your intellectual property and provide benefits in different ways. Businesses often use a combination of both registered and unregistered rights to provide comprehensive IP protection. So why register IP rights? It does give you exclusive control over its use, offering opportunities to sell, license or develop your product while trying to limit competition. It also safeguards your idea from imitation and can open up new opportunities, such as you could use it as a negotiating tool when seeking third-party funding or attracting investors. And having the ability to navigate and understand IP rights is an invaluable skill for any researcher, particularly those who are looking to commercialise their research. Once IP rights are registered, there are multiple ways to benefit and commercialise. One benefit from IP protection can be gained through you yourself manufacturing the products for others, Alternatively, the organisation may plan to sell off or assign the IP. The organisation that you work for may also consider licensing the IP. And there are also other benefits from others adopting and further developing your technology, as we see with cases of this with companies like Tesla and IBM, who license a lot of existing technology. We're all aware that the journey for a startup and innovator is challenging, and getting the right investment or funding can often be that really crucial step to continuing your research project. International studies estimate that patents and trademark ownership increase investors' estimates of a startup value by about 20%, especially in the early development stage and in early financing round. And research has shown that when compared to their peers, Australian firms with patents obtain more of their funding from innovation from external sources than those without patents. And in fact, multiple studies have shown that securing IP rights for early stage innovation provides that greater chance of success for others that don't. So I've given you a really brief overview of what we do here at IP Australia and what IP can do for you. Now I'm going to hand over to Senior Patent Examiner Firoozeh, and she's going to speak about all things patents. Over to you, Firoozeh.
Thank you, Julie, for that introduction. Good afternoon, everyone. Before we dig into patents, I want to clear up a common myth. One of the biggest misconceptions in IP is that patents prevent progress through restriction of use and secrecy. In fact, patents play an important role in scientific and technological progress because they reward and encourage public disclosure of inventive knowledge which might otherwise stay secret indefinitely. Patent ownership puts you in control of who and how your IP can be used. You can also choose to let others use your invention for free, such as free licenses, patent pledges, or for research purposes. Patents prevent competitors and other market actors, such as firms that do not share your values regarding, for example, sustainability or labor practices, from using and benefiting from your ideas. An analogy that I like is from Frank Teaser, is that a patent is like a front door of a house. Imagine your house without a door. Without that door, anyone can come in, sit at your table, take a drink from your fridge, and maybe even sleep in your bed. Without a front door, you might find it difficult to control the use of your house. Installing a door puts you in control of who you let into your house. Even with a door, you can have an open door policy and invite your friends over. Having a door also allows you to be more restrictive, for instance, only allowing close family with an invitation to dinner. The door, that's the patent, enables the resident, the owner, to be in a position to make decisions. Without it, it would be difficult to restrict who will be around the house, that is, who will be using an invention. A patent provides exclusive rights for a device, a substance, a method, or a process that is new and inventive and useful. On this slide, we have 3 known examples of patented items. Google Maps, developed by 2 brothers in Sydney, which was later acquired by Google, the cochlear implant, and the Palmer banknote. Patent protection gives you exclusive right to determine how your patent can be used and who can use it. Protection of your patent can last for a maximum of 20 years and can be extended for an extra 5 years for pharmaceutical patents. It's important to note that you shouldn't share or publish your idea before filing for a patent. This is because if you apply for a patent, it must be new and inventive over what is publicly available, and this includes your own publications. That's a basic premise of a patent. You're securing a monopoly in exchange for putting your idea forward in a patent system, which will eventually be published. If you want to discuss your idea with employees or business partners, have them sign a confidentiality or a non-disclosure agreement. We'll speak more on NDAs later. If you've already gone public with your invention, you enter a period of 12 months. This is called the grace period. This means you have 12 months to file your standard patent application. So some things to consider prior to submitting a patent application. Can my idea be patented? If it's clearly a product or process, then you're on safe grounds. If your idea is purely theoretical, artistic, or a business matter is similar, then likely not, and different forms of IP protection, such as copyright or trade secrets, may be more appropriate. Is my idea different? As a potential inventor, you should do plenty of research. It is common to review the work of competitors and search the internet. We encourage applicants to search patent databases. Each patent office will have its own national collections. In Australia, we have the Australian Patent Search on IP Australia's website. Another search tool is Google Patents, which hosts patents from all around the world and goes back many, many years. Just because a product can be found on a Bunnings shelf doesn't mean that it wasn't invented, for example, 50 years ago in France. The next two steps often go together. A patent is only needed if you intend to commercialize your product in the market where there is competition and you intend to enforce your rights. If your idea is a new toy for Christmas and your business plan is to hit the market hard, build a strong following, differentiate based on brand, and then slow down manufacturing to concentrate on another idea for next year, then a patent might not be the best fit for you. If you have spent many years on R&D and your product will be in the market for many years and can be reverse engineered by a competitor, then a patent might be a great idea. Other considerations include which countries will you take your product into and how well can you prevent copiers and dupes. Specifically within research, think about what you need, why you need a granted patent. Is it to secure investment funding, or if you're collaborating with others, what do you bring into that relationship? Regarding professional advice, always encourage businesses or inventors to seek professional advice. Patent attorneys or lawyers with science and engineering degrees who specialize in patents. Much like hiring an accountant to do your taxes, you may consider using a patent attorney, as their professional expertise is a better use of your time and resources. Next step is to prepare your patent application. So the basic requirements you need to meet are that your patent needs to be new, it needs to be inventive, useful, and suitable subject matter for a patent. New means that the invention needs to be different to anything done before. When checking this, we search the entire world for identical and similar inventions. This means that you need to keep your invention a secret before you apply for a patent. If your idea is already visible to the public, even if you published it yourself, it is no longer new. Inventive means that invention must go beyond what is obvious, given the normal progress of technology. Useful means it can be made or used in industry. Manner of manufacture can be a complex subject, and it is assessed on a case-by-case basis. A simplified way of explaining it is that you can only patent inventions that have tangible form and can be manufactured. Further information on this is available on our website. If in doubt, please seek the help of a professional. So what are examples of inventions that can be patented? Devices or machines, such as appliances, mechanical devices, and computer hardware. Substances or biological inventions, such as isolated bacteria, and genetically modified organisms, such as plants. Methods or processes for producing such products and devices. A complex device can be covered by a group of patents. Don't forget your unexpected invention. Sometimes when you're working in a certain research area, you may need to adapt a particular technology so you can use it to further your research. So always have your inventor's hat on. What can't be patented? So there are some things that can't be patented, no matter how ingenious or unusual they may be. You cannot patent human beings, artistic creations, mathematical models, theories, ideas, schemes, or purely mental processes. We have more information about what can and cannot be patented on our website. It's worth noting that each country may have different requirements. There are some complexities on the patentability of certain inventions. It's important that you have a depth of understanding about the law, and if in doubt, get the appropriate advice surrounding patentability of such inventions. Business methods and software often fall in a gray area and may typically not be patentable. However, certain types of business methods and software can be protected with a patent. If broadly speaking, the nature of your invention is technical in nature. For software, this means that you're providing a solution to a technical problem, like improved graphic processing, rather than simply using a computer in a standard way. So much like conducting a preliminary search at the start of a research project, it is important to conduct a comprehensive patent literature search before applying for a patent. It's important to note that there is a lot of complexity in patents, so you need to understand patent law, processes, and practices in order to make that determination around whether or not your idea may infringe on existing IP. As always, if in doubt, seek advice. Navigating and understanding patent literature is a complex task. Allow enough time to conduct a thorough search. Many tools are publicly available for searching patents, each having its own benefits. IP Australia has its own patent search tool, which can be used to identify active patents in Australia. For example, to see whether there are existing patents you need to be mindful of, which may overlap with your innovation. If you're looking to search what's out there more broadly, check if your innovation might be new. Then there is Google Patents, the Lens, Espasnet, just to name a few. Beware of using the exact wording of your inventive concept when searching with AI-powered tools, as there may be potential impacts on data security and integrity. We will drop some videos on how to use the free search tools in the chat. Please note that approaches to searching these videos are examples only and do not reflect a prescribed or recommended practice by IP Australia. In addition, we take no responsibility for the search results you obtain when using these search tools and databases. So some patent options that we have in Australia. We have the provisional application, which is kept secret, but this application secures your priority date. It gives you 12 months to decide if you wish to file a complete application or a PCT application. It does not give you patent protection and is not published. International PCT applications are a great option to streamline the application process if you intend to seek patent protection in multiple jurisdictions. Get an indication of whether your patent might meet standards across many countries. You will still need to file a complete standard application, and this is called international phase. A complete or standard application is necessary for patent protection. It gives you the right to take legal action against others using your invention in Australia. It allows you to license to someone else for manufacturing purposes. This can be complex and you may require assistance in how to apply for a standard application. It is important to be wary of the nuances and timing around the cycle of each of these types of applications. For further detail, as always, see our website. So now I'll take you through getting IP ready. Commercialization of IP means extracting value through a new product or production method or service based on your IP. IP protection can reduce the risk of commercialization by deterring competitors from using your innovation without your permission. It helps you secure and extract value from your innovation each step of your journey towards realizing your innovation in the market. Your IP strategy should support the long-term goals of your research or innovation. You should consider protection of your IP, including your brand, product name, logo, design, technical drawings, databases, etc. Your IP strategy should be flexible and forward-thinking to include potential opportunities to obtain competitive advantage and potential monopoly. Consider your timeline. It will take some time for the patent to be examined and granted. IP may be assigned or licensed at any time during its life, including before creation of a commercial product. How long will you need to develop and take your product to market? However, patent can only be enforced against potential infringers or copycats once it has been granted. If you think there is a potential conflict out there, you can request for patent examination to be expedited. A registered patent in Australia would only cover you here. When aiming to enter different international markets, you will need to be aware of the legal requirements of those jurisdictions. IP protection management is important when collaborating with research or industry. And it's always best to make plans at the outset to prevent delays and avoid disputes. As we have seen thus far, there may be often partnerships involved in your innovation or commercialization journey. That's why we want to reiterate why it's important to consider what kind of IP might be involved before commencing a partnership. Whether it's background IP, that is work created before or outside of the collaboration by one of the parties involved. Whether it's project IP, that's IP that is being created during the collaboration, or even third-party IP, which is where you use existing IP owned by someone else, not involved in the collaboration. You'll need to navigate ownership carefully and early on, as this can otherwise cause problems with ownership, which is important for appropriately using, licensing, selling, and managing your IP. So non-disclosure agreements, we've been talking about that a bit today. What are they? A non-disclosure agreement, or NDA, is a legal contract used to ensure that a person who gains access to sensitive information doesn't disclose it to a third party. They're sometimes called confidentiality agreements. These should be established with every person who has knowledge of the sensitive information that you want to keep secret. An NDA should state why you're sharing confidential information, as well as a timeline for how long it is valid for without specifying the confidential information itself. As it is a legal document, we recommend you find a professional to review your NDA to ensure it's appropriate in scope. So quite often you'll see an NDA that says this NDA expires within 2 years after the date it's signed, or something to that effect, which might be okay if the plan is to file for a patent application within that time frame. But if the IP is a trade secret or know-how, that's no good at all. You don't want them to be free to disclose the trade secret after 2 years. So an NDA can and should last as long as a secret lasts. If you're interested in learning more about NDAs, we have lots of information on our website, as well as an IP contract generator tool that allows you to create your own NDA. An IP disclosure form is necessary usually when you're dealing with technology transfer offices, because these forms include the invention, a description of the invention, commercialization potential, the details of inventorship, and other information regarding disclosures and obligations. You should notify all co-creators of the IP about this disclosure and ensure they're satisfied with the content and accuracy of the submission. If your institution does not have a form or process, you can use the guidelines in this slide. A technology transfer office, or a TTO, you can find one within most universities. What they do for you is understand your obligations and your IP obligations and rights, draft and sign an NDA for you or other agreements with collaborators. They can draft patent specifications. They can have access, provide you with access to commercialization support and tools such as pitching, access to financial support, and much, much more. So finally, beware of accidental self-disclosure. To be eligible for patent protection, an invention must be novel and inventive over what is called the prior art. Prior art includes any information made publicly available before the priority date of a patent application. You should avoid any disclosure of your invention before filing for a patent application. Self-disclosures will become prior art against you, so prematurely disclosing your invention will jeopardize a future patent position. This is the biggest pitfall for all inventors across the board. Keep in mind, the same material can be patented and published as long as the provisional patent is lodged. Journals are increasingly making publications available online before the publication date. Grant applications are not considered public disclosures, but a title and abstract may be published online if successful. Discussions with collaborators and industry partners with a full confidentiality agreement are not considered to be prior art. You also want to avoid publishing anything that may make your invention obvious. The place where this happens the most often is the future works section of journal articles, where it's common to hypothesize about future works. Now I'd like to hand over to Julie, who will take you through the next bit about IP commercialization. Thank you.
Thank you, Firoozeh. That's fantastic. That's been a really great introduction and getting to patents, Firoozeh, and also getting ready for IP. There's obviously quite a lot to keep in mind on your patenting journey, and just a reminder to everyone online today that we are going to share the slides after the presentation and that the session's being recorded, and we can share the link with you also, just in case you haven't got everything jotted down. So I just want to talk about some considerations for commercialization right now, and often the circumstances of IP creation during research commercialization can result in issues around ownership, whether it's sole ownership or joint ownership. It could also be whether it's your personal IP or belonging to your university or research organisation, or even owned by the company you work for if you're an employee. It's really important to know that the owner of the IP isn't always the person who created the IP, and that you need to check you're the rightful owner before applying for IP rights and taking legal action. So generally the creator typically owns the IP, however it does also depend on other factors such as employment. So in Australia, IP generated through the course of employment is typically owned by the business, and any exceptions to this must be in the employment contract. At a university, it will depend on your university's IP policy, so I really encourage you to read this. And this determines ownership for staff, students, honorary appointees, and even visitors to the university. It's also worth noting that IP policies in universities may typically specify a duty of disclosure. That is, you have a duty to disclose to the university any IP you create in relation to your related activities at that university. As Firoozeh mentioned, when it comes to collaboration, IP can have more than one owner, and it can belong to the business, organisations or individuals. And these are typically governed by a collaboration agreement. If one or two parties have created the idea together, they typically become joint owners. In some instances, you may have a material transfer agreement in place or an MTA, and this involves situations where an IP owner agrees to provide their IP to another party. So for an example of this would be when a company provides a strand of mRNA for researchers to conduct further R&D. And such agreements may typically require that the party receiving the material assign ownership of any new IP to owners of the original IP. So these are just things to keep in mind around IP ownership. One other valuable thing to do in your research project and research development is monitoring registered IP. And this can help you stay ahead of the curve, and it will help you understand what kind of patents and designs are being filed in your technological domain. There are significant benefits to this. It can actually help you inform your research direction and priorities and provide rich information on developments in that particular domain in your field. It can also provide competitive intelligence and help you understand where your competitors are operating. It's also really important for risk mitigation, and it can provide an early warning system on existing IP developments and can help inform you about where you might have freedom to operate. As many of you are probably aware, freedom to operate assesses whether a proposed product or technology can be developed without infringing on existing IP. I just want to touch really briefly on the risks associated with IP protection. And I guess, first of all, it's worth noting that the longer you wait to consider your IP, the more significant many of these risks can become. So some of the risks include a failure to protect, that is not taking the necessary steps to protect your IP, which can result in a loss of rights and potential financial loss. It may also result in a reduced ability to secure investment or loss of product market share, and even your competitive advantage. In this picture here is Gecko Tracks, which is an all-ability tyre for wheelchair users. And this is a startup company. They sought advice just from their mentors about what they should do with their IP. And initially they only protected their invention using a design right and didn't consider a patent as a part of their initial strategy. Later down the track, when they went to file for a patent, they faced some challenges because their invention was in the public domain and considered prior art. So I guess this is just one example of seeking that advice, seeking professional advice to be confident in your IP strategy. Another risk is infringement, and this occurs when someone knowingly or unknowingly uses another entity's already registered and protected IP. If you're found to be infringing on protected IP, you may need to stop commercialization of your idea. There are instances of businesses who have infringed on another's IP having to rebrand and destroy stock, which can be a huge cost to a business. There's also risks associated with transferring technology from one entity to another, such as losing control of your IP or it being shared with a competitor, and this is where options such as an NDA come into play. I guess the message we'd like to get across is that to try and mitigate these risks, it's critical to have a robust IP strategy in place, and this includes regular audits, diligent enforcement of rights, and seeking professional advice where necessary. Finally, before we move on to our scenario, here are our overall tips for IP management. Consider your IP early. It can be the difference between success and failure. Each type of registered and unregistered IP has its own benefits, restrictions, timeframes, and costs. Identifying who owns the IP, both Firoozeh and I have talked at this about IP ownership and co-ownership. If you've been employed by someone to design a product, it's likely that that employer will own the IP. So be really clear about who owns the IP at the start of a project. Special rules may apply for IP created by university academics, students and researchers, and this again will be outlined in the IP policy. Speak to your commercialisation office and speak to them early, and they are there to help you and understand your IP obligations. Learn and understand how different IP rights can work together to protect your idea. The slide that I showed really early on in this presentation about the registered and unregistered IP rights, and have a think about how they can work together to protect your research and your innovation. When you register your IP, it will be published online. This is so others in the marketplace can be aware of what you're protecting, so you need to consider this, this as an implication in your IP strategy. Design rights and patents need to be a secret until you apply. Understanding the relationship between copyright and design rights is also really a useful thing to know. Generally, you cannot protect your design with both copyright and design right at the same time. If your product has a short lifespan, there are alternative strategies that do not necessarily include registering your IP, and Firoozeh touched on this early on in the patent section, thinking about your invention, your innovation, and taking it to market and how long it's going to be in the marketplace. It's important to have a strategy in place to identify what steps you will take if you find someone copying your design or using it without your permission. So the enforcement is up to you. At IP Australia, we do not police IP or launch legal proceedings on your behalf. And a registered Australian IP right does not give you protection outside of Australia. Don't be afraid to get help. Turning an idea into a commercial reality can be uncertain and daunting. And so if you need financial, legal, business advice, there are IP professionals who can help. But if you need more general information about IP rights, we've got some really great resources and information on our website. I really encourage you to visit that. So here is a slide that's got links to some of our fantastic resources on the IP Australia website, linked to the patent search. There's some really great information on commercialisation and collaboration. And I also want to give a shout out to our patent case management service, which is open to those small and medium businesses who are looking to apply for a patent and haven't already sought legal assistance. Firoozeh is someone who works in that team, so you may get to speak to her if you're lucky. So now we're going to switch gears a bit and we're going to move to our mock scenario. And we've developed a mock scenario of a researcher looking to understand their IP rights to protect their current research, which they want to perhaps use to commercialise their discovery. So we're going to have Firoozeh join us again, and we're also going to be joined by patent examiner Nidal Hadeh, who will provide insights on how they might consider IP rights in their future plans. And we've developed this scenario based on experiences in examination and common challenges that researchers and academics often face in their journey. So I'm going to bring in our researcher. Hello, Selena. Today we're joined by Selena. Selena joins from the University of Australia. So Selena, welcome. We'd love you to tell us a bit about yourself and your invention and what are your plans for the next 12 months.
Hi everyone, hi Julie. So I'm an early career researcher working in microfluidics. Without getting into too much detail, my research makes use of surface tension forces and a unique system to control and improve the properties and behaviors of fluid movement. My vision is that my system can be applied to an implantable medical device for diagnosis and treatment. There is another aspect to my invention, which captures biosensor data and utilizes machine learning techniques for risk assessment. In the future, I predict this technology will enhance existing fertility treatments and IVF technologies. So as my research is coming together, I can see that there might be some commercial value in the future. I'm really interested in taking the next step. Can you tell me if my invention is patentable in Australia?
Firoozeh, I'm going to hand this one over to you.
Sure. So what you need to consider is the concept of a manner of manufacture. This is a rule that can be quite complex and is assessed on a case-by-case basis. A simplified way of explaining it is that you can only patent inventions that have tangible form and can be manufactured. What immediately jumps to me is that you're explaining a very complex area of machine learning, AI, and other types of computer implementation. So this can only be patented if it has technical character. This can be tricky to determine without a thorough understanding of the Patents Act. To better understand manner of manufacture and the substance of your invention, we encourage you to visit our website and also to seek the advice of a patent attorney who is best placed to draft your patent application. They will be able to provide you specific advice on your product or service as well as protection strategy. As to the potential applications in fertility treatment, I want to flag that you cannot patent the biological process for the generation of a human being in Australia. Again, further information can be found on our website. Bringing an implantable medical device to market involves navigating a complex life cycle filled with rigorous testing and regulatory hurdles over several years. A standard patent application provides protection for up to 20 years. Deciding when to beginning the patenting process will be critical to this part of your journey.
Thanks, Firoozeh. That's really great. Selena, do you have any other questions about patents?
Yeah, actually, I was wondering, will publishing my research change how I can patent?
In a word, no. While publishing and patenting have a similar requirement for novelty, patenting will not impact the novelty for publication purposes. There is a common misinterpretation of the phrase used in many journal guidelines. Articles published must be original research, which has not been reported or submitted elsewhere. This does not preclude patenting. You may, however, need to inform the journal of your financial interest in having your research published. The publication of your research article is likely to cause the value of your patent application to increase. If you have any doubts, you can review the requirements of publication in specific journals. I cannot emphasize enough that before engaging in any disclosure or publication, it is best to talk to your institution's IP office first and then seek IP advice. You can be assured that you can pursue patenting and publishing together and enjoy benefits of both. For the sake of completeness, a competitor will not be able to get a patent on your research based on your publication, even if you choose not to patent, because an invention cannot be patented if it has already been publicly disclosed. Your publication can preclude you and anybody else from obtaining a patent on your invention.
Thank you. And what if I've already gone public with my invention? Can I still patent?
Nidal, would you like to jump in here?
Yeah, sure, Julie, thanks. That's a good question. So if you have already gone public with your invention, you enter a grace period. This means that you have 12 months to file your standard patent application. If you try to file beyond the 12 months, the initial public disclosure can stand in the way of your application. Now, the grace period covers public disclosures of an invention made by you with or without your consent. And you don't normally need to, formally apply to claim the grace period. But it is important to consider that not all countries offer the grace period. So this means your protection options in certain countries could be limited if you choose to expand to these markets later. So I really urge you to consider the grace period only as a backup option, a last resort.
Okay, thank you for that, Nidal. That's really helpful to know. Just one more question from me. There's a local microfabrication company that I'm thinking of starting a new collaboration with. What are some safeguards I can put in place to protect my IP?
So if you need to talk to others about your idea, you need to be sure that they will not disclose your idea to anyone else. You can use a non-disclosure agreement to formalize this. We have a fantastic free contract generator tool on our website, which you can explore. Now, if you urgently need to talk to others about your idea before putting a formal agreement, you can use some general statements regarding your work instead of being explicit, and precise about your idea. And before any discussions, publications, or disclosure, we strongly advise you to speak with your institution's office. Normally, your institution will handle and sign contracts with any collaborators on your behalf.
Great, thank you so much.
Thanks, Selena. Thank you so much for joining us on our webinar, and thank you to our examiners, Firoozeh and Nidal, for their really insightful answers. We hope that these answers can help clarify some of the nuances. It's, IP protection is very nuanced, that some of these answers can help you navigating your IP rights in a research setting. Please visit the IP Australia website at www.ipaustralia.gov.au for more information. And we also have a contact centre at IP Australia. The phone number is 1300 651 010. This is all on our website. I just want to reiterate that as a government agency, we can provide information but not advice. If you do have technical and legal questions, you may need to speak to a legal IP professional, and just keep this in mind. It's been a really fantastic session. Thank you to Firoozeh and Nidal for your wonderful contributions. Thank you, Selena, our researcher, and thank you to Rhiannon and Kai in the team. We would love your feedback. We want to know, what do you need to know? What do you need to know more about? So please provide some feedback to us. We would love to hear it. And we've got our contact details here on the screen right now. We have an outreach inbox. Please, any questions that you think of after today, we are here to help. So please reach out to us. You are welcome to do that at any time. And I just want to thank everyone who's coming along today. Again, feedback is most welcome.